Hi everyone, welcome to today's Legal 101 on tax law being a Tuesday. And it comes to you courtesy of the Income Tax Act and a judgment by Justice Mshila in 2023. Now, when it comes to tax disputes, the natural order of things is that KRA issues its decision. If, as a taxpayer, you are aggrieved, you lodge an appeal before the Tax Appeals Tribunal. If you're still aggrieved by the decision of the tribunal, an appeal before the High Court and then the Court of Appeal, and so on and so forth. So, today we are going to learn about the tax implications of issuance of an allowance and receipt of that allowance. That as an employer, when you are giving allowances to your employees, what are the tax implications? Now, the facts of the case. There are two companies, Company A and Company B. These companies enter into an agreement where Company A is providing services to Company B at a workstation that is outside Company A. So therefore, Company A has to send some of its employees to Company B's workstation. Now, it's not something that happens often, it happens from time to time. And while these employees are over there working, they receive their meals and accommodation courtesy of Company B. Okay? The place where they are working is a place that doesn't have proper security measures, does not have hospitality services, so it just makes sense for Company B to provide those services. And then, when it's paying the contractual sums to Company A, it deducts the expenses incurred in making the meals and the accommodation. And then when Company A does its books, it records this amount as expenses. Now, KRA comes in and says, for these 2 years, July 2015 and March 2017, you Company A, did not declare income tax, particularly payee. That this amount is based off of gains or profits that you received or that were received in respect of employment. That there are certain gains and profits which attract income tax. And these are benefits accruing from wages, salaries, leave pay, sick pay, payment in lieu of leave, fees, commission, bonus, gratuity, or allowances such as subsistence, training and entertainment allowance received in respect of employment or services rendered. And so the court was tasked with determining whether the 18 million was due and payable. And this is what the court began by saying, that tax demands must be made out of express provisions of the law. That where the law is quite ambiguous about whether or not a deduction should be made and remitted, then it is time for the legislature to make an amendment of that provision of the law. Now, with this in mind, the court relied on sections 5 subsection 2 and section 5 subsection 4 of the Income Tax Act. And the court looked at what the definition of gains and profits was relevant to the issue of employment. And the court said, based on the case, there are only 3 types of tax exemption scenarios that these provisions of the law envisioned. Scenarios which I was expecting the taxpayer to raise for them to say, no, we are not supposed to pay this 18 million that KRA demands of us. And these were the 3 tax exemptions. That if an employee spends and is reimbursed subsistence, traveling, entertainment, or other allowance, any gain or profits received from this allowance is not subject to taxation. Number 2, if this amount we have spoken of is paid in respect to a period spent by the employee outside their usual place of work, okay? They had to work at a different workstation, then the first 2,000 shillings that have been reimbursed to the employee are not subject to taxation. And number 3, if an employer is providing meals to its employees from a canteen or cafeteria operated or established by the employer and operated by a registered taxpayer, and the value of the meal does not exceed 48,000 per year per employee, it cannot be said that this arrangement is so beneficial to the company or to the employer that the gains that come out of this arrangement are subject to income taxation. Now, the court therefore said that I did not see any of these exemptions raised by Company A. What they said was that food was provided because of a necessity. That's not one of the exemptions under Section 5 of the Income Tax Act. It doesn't matter that food was provided because there was no other option. No. What matters is that there was an allowance. It was accrued outside office, the normal workstation. It was reimbursed. Those are the things that we would look at to determine whether or not a taxpayer is exempt from payment of tax. Devoid of that, the court said that KRA was entitled to the 18 million, and therefore the taxpayer was condemned to payment of that amount. Okay, so I hope that helps you if you're an employer to remain compliant. That helps you as an employee to understand your tax obligations. And yeah, that marks the end of today's Legal 101. Subscribe, share, ask questions, make use of the KRA website. Very often they provide updates on what is taxable and what isn't. Okay, sawa. See you tomorrow for tomorrow's Legal 101.